Hello and welcome to this episode of our series on data protection and pensions, brought to you by the pensions team at Gowling WLG. I'm Ian Chapman Curry and I've been dealing with all things data as the pensions industry gets ready to comply with the GDPR. As always, you can get more information on this and all our other pension insights at www.gowlingwlg.com/pensions-UK. In this episode, we'll be looking at what pension scheme trustees will need to communicate to members in the form of privacy or fair use notices. As data controllers, pension scheme trustees will need to consider a range of issues and take important decisions. The most important of these decisions is to decide what legal grounds they have for processing their scheme's personal data. The key points for this episode are that trustees will need to take some important decisions. As data controllers, trustees are ultimately responsible for the processing of their scheme's personal data. They will need to take decisions on important issues such as the legal grounds for processing the scheme's personal data. Trustees will need to establish the legal grounds for processing. Processing personal data is only lawful under the GDPR if one or more of 6 legal grounds applies. Trustees will need to determine the legal grounds for the processing of the scheme's personal data. Trustees will need to document their decision-making. One of the important overriding principles set out in the GDPR is accountability. Trustees will need to demonstrate A, that they have complied, and B, how they have complied. For decision-making, this means keeping records of how decisions were reached. Trustees will need to think about sensitive personal data. There is a general prohibition against the processing of sensitive personal data in the GDPR. There are a range of exceptions to this general prohibition, and trustees will need to determine which exceptions apply in order to continue to process sensitive personal data. What sorts of decisions will trustees need to take? As data controllers, trustees will need to take important decisions on a range of issues relating to data protection. For example, many trustees will need to consider what are the legal grounds for processing my scheme's personal data? What is the exception that will allow me to process sensitive personal data? Do we need to appoint a data protection officer, a DPO? How long do we keep the scheme's personal data for? Will this need to change under the GDPR? If we choose not to delete some of the scheme's personal data, should we at least remove it from online and office-based systems into secure archives? What should we put in the scheme's privacy notices? Who do we need to send these notices to, and when do we need to send them? Does my scheme have to have a data protection policy? Does it need to be reviewed and updated? If we don't have a policy, do we need to adopt one? How do we share information with employers and related third parties? Do we have an information sharing agreement with scheme employers? If not, do we need to adopt one? Trustees will also need to document their decision-making process and ensure that they can have a written record so that they can demonstrate compliance and accountability. This episode focuses on the legal grounds for processing, but it also sets out some guidelines that will apply for trustees approaching any decisions on data protection. Why are the legal grounds for processing so important for trustees to get right? Under the GDPR, processing of personal data is only lawful if one or more of 6 legal grounds, also referred to as lawful bases, applies. The ICO has been clear on the importance for data controllers of determining the correct legal grounds for processing personal data. What are the legal grounds for lawful processing of personal data? There are 6 legal grounds set out in the GDPR. Most of them will not, however, apply in the context of private sector occupational pension schemes. Necessary is used repeatedly in the legal grounds, which serves as a reminder of the GDPR's principle of data minimisation. So let's have a look at the legal grounds individually. Consent. data subject has provided consent for one or more specific purposes of data processing. Vital interests. The processing is necessary in order to protect the vital interests of the data subject or of another natural person. Contract. The processing is necessary for the performance of a contract to which the data subject is party. Public interest. The processing is necessary for the performance of a task carried out in the public interest. Legal obligation. The processing is necessary for compliance with a legal obligation to which the controller is subject. And finally, legitimate interests. The processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party. This ground is subject to a balancing test. So which of the legal grounds will apply for private sector occupational pension schemes? Trustees will need to review their scheme's personal data and the processing activities that take place. They may also seek professional advice before taking a decision. It's clear, however, that trustees of private sector occupational pension schemes will not be able to rely on all the legal grounds. Consent is unlikely to be a practical ground for the general processing of pension schemes' personal data, although it might continue to play a role in the processing of sensitive personal data. Contract-based pension providers may process on the legal ground that it is necessary for the performance of a contract, but this is unlikely to be useful for trust-based pension arrangements. Similarly, private sector pension schemes will not typically be able to rely on the legal ground of carrying out tasks in the public interest or protecting vital interests. So this leaves compliance with a legal obligation and legitimate interests. So let's take a look at those two in turn. Processing is necessary for compliance with a legal obligation. Under the GDPR, data controllers can process personal data if such processing is necessary for compliance with a legal obligation. The UK's data protection regulator, the Information Commissioner's Office, or ICO, has, in its Guide to the General Data Protection Regulation, confirmed that this ground can apply if you need to process the personal data to comply with a common law or statutory obligation. Pension trustees have a wide range of common law and statutory obligations. A lot of the scheme's personal data is processed in order to comply with these obligations. For example, the trustees' fiduciary duties are set out in trust law, which is part of the common law. When trustees exercise their powers of discretion on a member query, they're expected to do so in line with their fiduciary duties. Amongst other things, this requires the trustees to take into account all of the relevant facts and to discount all of the irrelevant facts. In order for the trustees to do this, they're likely to need to request, sort, file and review personal data relating to the member and other potential beneficiaries. The trustees' legal ground for this processing is that it is necessary for them to comply with a legal obligation, i.e. complying with their fiduciary duties when making a decision. UK legislation also requires trustees to process personal data. For example, in order to comply with a member's statutory right to request a transfer, the trustee will need to process that member's personal data. Again, this is necessary in order for them to comply with a legal obligation. Trustees will, however, still need to consider carefully what personal data they process and why they process it. Not all processing is done in order to comply with a legal obligation. For example, legislation requires that trustees communicate certain things to members, but trustees might also decide to send out additional communications that are not strictly required under law. If the processing is an unreasonable and disproportionate way of achieving compliance, the legal ground will also not apply. Trustees may therefore decide to take legal advice on what processing activities are necessary for compliance with legal obligations before they decide on whether or not this is an appropriate legal ground for the processing of their scheme's personal data. So what about the second possible ground? That the processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party. Legitimate interests provides one of the most flexible legal grounds for the processing of personal data. In order to protect individuals, the GDPR therefore adds additional wording that requires data controllers to consider the rights and freedoms of data subjects, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject which require protection of personal data. When the full text of Article 6F of the GDPR is taken together, it's clear that data controllers need to carry out a balancing test in order to determine whether their legitimate interests are outweighed by risks to individuals. There are 3 tests that trustees will need to apply in order to determine if the legitimate interest ground can apply in respect of the processing of the scheme's personal data. So what are the tests to apply to determine if a legitimate interest can apply? The first is the purpose test. Are you pursuing a legitimate interest? For example, the payment of the correct level of pension benefits to the scheme's beneficiaries is a legitimate interest for a pension scheme trustee to pursue. Second, the necessity test. Is the processing necessary in order for you to pursue your legitimate interests? For example, do you need to process the personal data in the way that you do in order to fulfill the purpose? Or is there a more proportionate or reasonable way of fulfilling the purpose? Finally, the balancing test. Do the individual's interests override the legitimate interest? As a trustee, you may have determined that you are pursuing a legitimate interest, for example, the payment of the correct level of pension benefits. You may have also have determined that your processing, for example, the storage and retrieval of bank information, is necessary to fulfill that purpose. But do the individual's interests override the legitimate interest? If you keep this bank information on a secure, password-protected system, this is unlikely to be a problem. If, however, you've decided to keep the bank information in an open folder, either online or in the office, then the individual's risk of being a victim of fraud might well outweigh your legitimate interests. Should trustees document legitimate interests? Trustees should consider their legitimate interests and set them out in writing. They should also consider the rights and freedoms of the data subjects and make sure that these considerations are also set out in writing. In most cases, this should be straightforward. Unlike in many online and commercial situations, the interests of trustees and members are more fully aligned than typical. Both parties want to ensure the full and correct payment of benefits to the right people at the right time. So what steps can trustees take to mitigate any risks to the individuals and make it more likely that they can pass the balancing test? The rights and freedoms of individuals are far less likely to be infringed if the trustee, as the data controller, takes appropriate data security measures. This might, for example, involve the trustee putting in place or reviewing their scheme's data protection policies, applying industry-standard data and cybersecurity measures, and ensuring that third-party service providers and professional advisors also comply with the GDPR. Can trustees continue to process sensitive personal data? Under the GDPR, there is a general prohibition on the processing of sensitive personal data, which is called special categories of personal data in the legislation. For pension scheme trustees, the most common form of sensitive personal data will be medical information. Other forms, such as information revealing race, ethnicity, religious beliefs or trade union membership, or data concerning an individual's sexual orientation, may also be encountered. In order to continue to process sensitive personal data, trustees will need to follow a few additional steps. First, what are the exceptions to the general prohibition on the processing of sensitive personal data? The most relevant exception conditions for trustees of occupational pension schemes are that the individual has provided explicit and valid consent, that the processing is necessary for the purposes of carrying out the obligations and exercising specific rights of the controller or of the data subject in the field of employment, social security and social protection law, or that the processing is necessary for reasons of substantial public interest as authorised by European Union or Member States law. What is explicit and valid consent? The GDPR sets a high standard for consent, and this is even more important when sensitive personal data is involved. Explicit consent under the GDPR needs to be clear, freely given, and in writing. Consent is likely to remain as an important part of the process of gathering sensitive personal information in respect of ill health early retirement requests, death benefit decisions, and IDRPs. Trustees should, however, ensure that how they obtain and record consent complies with the GDPR and seek legal advice if in doubt. If consent cannot be used, trustees should consider whether any of the other exemptions are available. So when do the other exceptions apply? There are 2 exceptions set out in the Data Protection Bill 2017-19 that could be useful for trustees of private sector occupational pension schemes. The first is where the processing is necessary to fulfil requirements under employment, social security and social protection law, and the second is substantial public interest, the occupational pension schemes exception. These exceptions are currently being debated as part of the parliamentary process for passing the Data Protection Bill. There are questions as to how they would apply in practice, which may be resolved as the bill progresses. Trustees should seek legal advice as to whether they will apply in their circumstances, and they may have to wait for the final version of the Data Protection Bill and/or guidance from the ICO. What about other trustee decisions on data protection issues? As outlined earlier in the episode, pension scheme trustees will need to consider a wide range of issues relating to data protection and take some important decisions. The principles set out for establishing legal grounds for processing can be applied to taking other decisions. Trustees should ensure that they fully understand the issues. This might come from training, such as reading, watching or listening to our guide, or attending specific training sessions or seminars. In addition, the ICO has produced a lot of guidance that can help trustees get to grips with their legal duties as data controllers. Where appropriate, trustees should also seek additional professional advice. Schedule time for decision making. Making time for discussion and decision making will help the trustees in order to make good decisions. Trustees will need time to consider the information and make informed decisions. Set aside plenty of time for this at trustee meetings and consider whether having a standalone meeting on data protection would be the most efficient way of dealing with the issues. Document compliance, that you've complied and how you've complied. As part of the principle of accountability, trustees will need to be able to evidence both that they have complied with the law and how they have complied with the law. A record of the relevant factors and the steps taken to reach a decision will be helpful if the trustee is challenged in the future. And if that has whet your appetite for all things data protection, don't forget there is far more information available at www.gowlingwlg.com. We've made all of these episodes available to read, watch or listen to whenever you want. Please do share them with anyone who is dealing with data protection issues. Thanks for making the time to join us. I hope you can join us for another episode of Gowling WLG's Data Protection and Pension series soon.